Okay, it is 10:01, and I think I see a few folks are still hopping on, but I think we've got most everybody on that's going to participate. Um, Hello, it's kind of fun for us to see on the Hollywood Squares, all of you jump on because it's like all of our friends are, coming to this super exciting chance to talk about policies with us. We are recording this webinar. Sherry will push that out to service subscribers and also post it to the Policy Service website. At this point in time, if you, I'm assuming everybody's looks like you're listening. So if you cannot hear us or if you're having audio problems, go ahead and use the chat feature. We do have it set right now to have everybody muted as they hop on. Because it's always annoying to me when I'm on a webinar as a participant when I can hear somebody like eating or moving their papers or whatever. We will unmute you all and give you a chance to ask questions when we get to that point in time. But for now, we have you all set to be muted. If you've got questions that you want to ask, you just have a burning desire to ask as we go, you can always use the chat feature on Zoom or good old-fashioned text message. You can text me. You should all have my cell phone number, but I'm going to rattle it off so you can jot it down on a piece of paper if you want it. I'm waiting while Newman Grove gets their pencils ready. Gosh, you are great students. So my cell phone number is 402-499-0547. 402-499-0547. And again, we will unmute you all and give you a chance at the end to have a free-for-all. But if you've got questions as we go, if you text them to me, that would be awesome. We have you, so as we're looking at you, we see like the Hollywood Squares of little tiny squares. If you don't like that, if you want to just see us, if you run your mouse over the video of us, the little square that we're on, there should pop up a box on the upper right-hand corner with 3 little dots. If you click on that box, a drop-down menu should come, and you can either pin our video to have us be big and everybody else small, or you can spotlight the video, which does something similar, only the sizing is slightly different. But that's what I do when I'm a webinar participant, so that I see the speaker and not everybody else. If you like to creep on, what Dana's doing while she's sitting there listening, you certainly can leave it on the Hollywood Squares. Last thing, we are assuming, we went back and forth about whether or not to have the policies up on the screen or to have us up on the screen. We think we're gorgeous, so we thought we'd just have us. I think it will be easier for you guys to have the policies on your desktop as you go. So we're going to assume you have when we're going to work our way through that cover memo. So we're going to have that cover memo. If I were you, I'd want that cover memo up on another screen or have it printed out. And that's the order that we're going to run through this stuff, right? Okay, all right, I'm going to stop talking.
One other thing, several people have asked so we may shorthand this a little bit by saying full service subscribers versus update subscribers. The concept being if your district has purchased the full KSB policy service and not just the updates, then the full policy service comes with the handbooks. And so we've been getting questions from folks, okay, policies are out, when are the handbooks coming out? We're hoping here in the next couple of weeks, but our goal for sure is to have them out in plenty of time for you to review our suggested updates to KSB's form handbooks prior to your June meeting. So knock on wood, with any luck, we hope to get you everything that you'll need to update policies and handbooks at your June meeting if you want to work that fast. And that was kind of our thought in getting things out a little earlier this year. So those handbooks to full service subscribers will be coming out and on the website and all that stuff soon.
Awesome. Okay, so we're just gonna, like I say, work through the memo in order, and whichever one of us took the lead on the policy is gonna take the lead in the webinar. So, but I don't know who did 2002, is that you?
Yeah, I've got policy, so we'll start with policy 2002. We haven't touched that one in a while. That's the organization of the board policy. And the reason that we modified it this year, and you'll notice that it says that this change is not required, but we at least recommend that you think through it, is you never have a stalled vote to elect a board president until you have one. And a lot of times it ends up in the paper. So what we did is put forward some options for you to consider as it relates to, okay, we don't want to go through 150 votes to elect a board president. Once we get to this many votes, here's how we're going to do it. So there are a couple of options for you to consider. Your board may say, oh, hell, that's never going to happen here. That's no problem. You don't have to change the policy. But it's happened enough, and it's been in the news enough that we wanted to put some options out there if your board wants to kind of have all that set before, you know, it becomes crisis, which is kind of a theme of a lot of the changes that we made this year. Sort of, I don't know that it's a required change. You'll notice in the memo, we probably have fewer of them that say this is legally required. But this is one where, again, I think it's a lot better. Karen will talk about memorials when we get there, for example. Things that your board should think through and decide now so that it hopefully staves off some of the political issues later. So nothing fancy about it. That's it for 2002. You'll see if you look at the red lines or in the middle of that policy, it talks about if in the event you have ties or nobody wants to run for an office or something like that.
Next, we have complaint policy, policy 2006, which I think is one of the most important policies in the deck. You want me to take the lead on this, or do you want to?
I did the end part, but I think somebody else did the middle part.
Well, so I guess I'll start. Whoever wants to put an or in can. One of the things that we've done to this policy is add a provision about the person that files serial complaints. 2018 has been a difficult year for a lot of school districts. I think a lot of you have heard me say this is the toughest, most like emotionally exhausting school year I think I've had in my 20-some years of representing schools. And so one of the things we've done is try to address the idea of somebody that files repeated complaints over and over again. And so what we've done is said that if you have filed multiple complaints, or if you're evidencing that you really have no interest in a good faith resolution, we're going to short circuit your ability to work through the complaint process over and over again. So it's not required. I think it's something that you as a district should consider, whether you have these people that are going to file 10, 12, 13 complaints in a school year. And if you do, you might take a look at what our options are to short circuit that.
Yeah, that's at the very end of the policy. We added that serial or bad faith filer.
You want to talk about this?
Yeah, we also added a standard of evidence for when students are accused of misconduct. The Department of Education is rejiggering how it handles mostly Title IX complaints and sexual harassment complaints. But it's established that the school can pick the standard of evidence that it's going to use, and we recommend having the same standard of evidence for all cases of student misconduct. In one case, the Department of Education said that if you had a lower standard for sexual misconduct complaints, that could result in discrimination against the student who's been accused of the sexual misconduct. So we want to, of course, avoid that and keep the complaint procedure as clean as possible. As Karen mentioned, it's one of the more important policies. And when we get to 5026, you'll see how we've reworded 5026 and 5027 to better funnel things into the complaint procedure in 2006 to try and have one complaint procedure that fits everything, which means you need to have one standard of evidence. And that's going to be preponderance of the evidence standard. You can go clear and convincing, and that's a higher evidentiary standard that's required for the investigator to find student misconduct. But preponderance of the evidence just means it's more likely than not. It's a common sense standard. It's generally what you're going to do anyway, just as an administrator. That's what feels natural. So that's what we want to apply to all cases of student misconduct.
Okay, I think that's 2006. I would give every new board member a copy of this policy and tell them to have it by their phone, because I just think this is one of the most important policies you can put in board members' hands.
Like I said, we direct everything there. That's sort of the purpose of the serial filer. I think if you directed more people who just want to come in and complain to you to that procedure, they're going to realize, wow, I've actually got to formalize it and put it in writing, and I can't just come in and say whatever the heck I want. So that's been our recommendation to deal with a lot of these difficult parent issues. We've got a complaint procedure. You should follow it.
I think 2007 is you, Steve.
Policy 2007. State law says you guys get to have one recognition dinner per year. Apparently they've seen Bobby, Karen, and Tim eat at your dinners because they've doubled the amount that you're allowed to spend now from 25 to 50. It's actually the first time they've changed that number. It took them 25 years, so they're really just keeping up with inflation. So we do have that dollar number in our policy. So if you want to increase it, you need to change the policy. It's not required, but if you don't change it, you're going to be limited to that $25. So my suggestion would be go ahead and change that up to the $50.
Okay, that's 2007. Now we'll move to 2013. This is violation of board ethics. This is one that unfortunately came about because of a Attorney General open meetings complaint, where essentially the school district went into closed session, and the purpose of it was to prevent the needless injury to the reputation of one of the board members. Now, if you actually look at the open meetings statutes, which, I mean, if you haven't in a while, there aren't that many of them actually, and we think a good refresher on appropriate closed session use is important anyway. But if for no other reason, it prompted us to take a look at what we had in our violation of board ethics policy. The concept being some board member flies off the handle and does something that either the administration and probably the rest of the board isn't okay with. What are the options that you have to address that? And the fact of the matter is, in Nebraska law, it's not many. So in this case, the allegations were, I guess, strong enough that this board said, well, let's go into closed session and kind of hash it out. Let's talk about the reputation damaging stuff to that board member while we're in there. We're not going to take any action, but certainly it's to prevent needless injury. So they decided, the Attorney General, though, with a pretty sweeping statement in their opinion, that they do not believe basically that it's ever appropriate to use closed session to protect the reputation of a member of the public body. Now, I'm not sure we agree with that, actually. I think there could be, we can envision a set of circumstances, in fact, it wouldn't be hard to come up with something that's not very hypothetical, where the reputation of that board member truly could be damaged if the rest of the board had to discuss that in open session at the meeting, if it related to school business. So while I don't think, we're necessarily saying you can never, ever, 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 ever use closed session to protect the reputation of a board member, we've changed this policy because it used to say that the board could go into closed session, that the board could go into closed session to talk about a board member. So the only thing that changed in there is we took that out, but I think it's an important reminder, though, that, they do field these complaints and say pretty sweeping things about using closed session. And I think the marching orders from us moving forward will be, if you can, at all costs, avoid using it to protect the reputation of a board member.
This is a change from the advice that school attorneys have given you for years. We have always said that if we were gonna try to sanction a board member or admonish them, that we should go into closed session and hash that out amongst the board. I'm sure NASB has given that same advice. I know the Perry Law Firm has, because we've given that to the same clients at the same time. I've always thought that the statute says you can go into closed session for reasons such as, so like the list in the statute is supposed to be exemplary. And if you can go into closed session to prevent damage to an employee's reputation, in my mind, you should have been able to go into closed session to prevent reputation injury to a board member. But so what this policy update is telling you is that the Attorney General has changed how they're interpreting, or they've changed how we're giving advice. So even if I've told you or someone else has told you in the past that it's okay to go into closed session to do this, the AG's office disagrees with that. And it's, there are risks that just aren't worth taking. And once they tell us we can't do it, I think you probably should comply with that.
The next policy is 3020, copyright compliance. To be honest, this is one that we haven't taken a look at in a while. And so our reason for getting into it has really been just an influx of copyright questions. And so I had done a couple of copyright presentations and had occasion to go back through the copyright statutes. Pretty much all of Chapter 17 of the federal statutes is addressed at copyright compliance and other issues. So what I did is sort of go through that and pick out, there are a few really specific educational purpose exemptions. So if you've taken a general or basic copyright training, you know that the concept of fair use for an educational purpose, you've heard of de minimis, those sorts of things. By far the greatest copyright argument that you have, if one of your teachers or students has stolen something off the internet, is for an educational purpose. Depending on the media that they've stolen, you actually can strengthen the school district's position in terms of defenses to like a cease and desist letter or a copyright lawsuit, if you've taken certain steps to inform staff and students that they shouldn't violate copyright law. So I think the heavy lifting in this policy in terms of the changes is requiring you to make available to your staff members copyright compliance materials, and that includes students. There are 3 specific sections of the copyright law that talk about if you've at least done your level best to tell them not to violate copyright law, then you've got a much stronger argument that yes, it was for an educational purpose and those sorts of things. So it's not really anything that's, the law and copyright didn't change. But as we continue to, digitize more and more of what you're doing, especially in just the general ed classroom setting, the more important it is to consider copyright. So we are going to be doing a big presentation on copyright, which hopefully some of you will be able to attend. We'll have some of your staff members attend, or at least maybe make them watch the recording, where we intend to kind of take a deep dive into, more than just the hour-long presentation concept on copyright. But this policy, I think, is also one that's important to circulate to all of your staff if the board makes the changes. It makes very clear what staff members have to do, for example, if they're not sure whether they'd be violating copyright by photocopying that New York Times article 20 times and handing it out in class. It basically requires them to run it upline to the building principal or superintendent to get permission to do that. So take a look at it. If you have any questions as we go through, let us know, but that's the basis of that change.
Well, one other thing I would add to this is that you're in your best position to defend a claim if you've actually provided training. So circulating maybe an article that everybody's supposed to read, or at least having a PowerPoint slide on don't violate copyright on your back to school stuff, that's really useful to you from a legal perspective.
All right, policies 3022 and 6027 go hand in hand. One of our districts who's in attendance here today has some lovely community members who have a lot of free time and want to volunteer at the school district. And so apparently, since they can't get hired being convicted felons, they spend their day at school. So essentially, there was a questioning of authority in these cases. How dare you exclude me from volunteering or chaperoning your field trips? I'm a great guy. That was the past. This is the present. I've served my time. You can't hold that against me. Well, no surprise. Yes, we can. And so we made it clear in both of these policies that the superintendent's decision about who can and cannot chaperone these events is final. We make it clear you can deny them for any reason as long as it's not an unconstitutional reason. So you can't deny them because of their sex or because of their race or something like that, but you certainly can deny them because they're a convicted felon. We went back and forth with how much specificity we were going to put in these two policies. If you take a look at it, we've actually only added one paragraph that is comprised of 3 very short sentences. If you want to make it more specific about who you're excluding, you can. We've intentionally not done that so that, again, we don't have one of these people go, oh, you missed this category, so you can't exclude me. But if you do want to list some specific categories, let us know. We'd be happy to change that and make it more specific for you.
Oh, sorry, I was busy tweeting and now it's my turn. Next is 3023, which is records management and retention. This used to just be electronic records management, and this is another one like copyright that we sort of ended up doing a deeper dive. To me, this is the advantage of having a service. The old version was acceptable. This one's tons better. So the Secretary of State's office has recently completed doing an update of Schedule 10. That's the part of the Secretary of State's record management retention schedules that applies specifically to public schools. So you need to have Schedule 10 and Schedule 24 kind of in the back of your mind as the 2 schedules that govern when you are required to keep stuff and when you are allowed to destroy stuff that you have gathered as in the pursuance of your duties as a public school district. And when I say stuff, I do that on purpose. When I say records, people tend to think of paper. And the definition of records is super broad. It includes your security footage. It includes everything that's electronic and digitized on your computers. It includes your PowerSchool and all the electronic records that you now have instead of paper records for students. So since we have electronic records issues coming up, and since Schedule 10 was amended, we've revised this policy to have it cover both the electronic aspect that we had before, as well as kind of cover your obligations under Schedule 10 of the Records Management Act. Now, there is in the middle of this policy a place where you're going to have to make a choice. So much of the work that we do is now governed by either Google Apps for Education or Outlook or whatever system that you're using for your electronic communication system. We have written different versions of this policy based on the different options you have for electronic communication. So if you use Google Apps for Education and you have enabled Vault, there's one choice. If you use Google Apps for Education and you have not enabled Vault, there's a different choice. And if you don't know the answer, or if what I'm saying to you doesn't make any sense, you need to go find the little troll that you have in charge of your records or your, computer system at the school, and drag the troll into the sunlight and make him or her tell you what they have, right? The vast majority of you listening to us, I believe, have some version of Google Apps for Education, and I suspect that most of you have not turned Vault on, but you need to confirm that with your tech person. I know that there are some schools that are using Office 365. They have much more granular, you can drill down and much more specifically control who retains stuff and who doesn't. So you're gonna have to have a more specific conversation with your tech person. And then we have a few districts that are still using servers in the school building itself to manage their electronic communication. So you're gonna need to choose one of the options from that policy that applies to you. Secretary of State's retention schedule requires you to keep short-term communications for at least 6 months. Things like tweeting out these state track meet finals starts at 4 p.m. tomorrow. I believe that falls under short-term communications, because the reason you're tweeting that is to communicate with your public. So we have a little section in there specifically about social media, and it just says that we're going to leave that stuff up on Twitter for at least 6 months. And most of that stuff, the social media platform just holds on to it and it rolls off whenever Twitter rolls it off. But you would at least have governed your obligations under the Record Management Act. And that way, if somebody shows up demanding to see all your social media posts, you're not freaked out like, oh my God, I was supposed to keep it and I didn't, because we have covered in the policy. Last thing I want to draw your attention to is security camera footage. We've had this come up more this year than ever before. Where a patron is unhappy because they think their kid is being bullied, or a kid falls down on the playground and parents want security footage, and the attorney sends a nasty-gram to the school. And so the person in the Secretary of State's office that revised Schedule 10 is named Austin Rhodes. He's a really nice kid. And so I ran this whole policy past Austin, and working with Austin, he has agreed with us that we can call your security footage working papers. Now, I know it's not on paper. I know it's, zeros and ones, but that's the part of Schedule 24 that would best apply to security footage, is calling it a working paper. The good news is, if it's working papers, it can be destroyed as soon as you don't need it anymore. And most of your security systems has like an auto overwrite after, so many days or so many weeks. And so if you call your security footage working papers, you're allowed to overwrite it if you don't need to pull it off and save it for any particular reason. Do notice that you're supposed to fill out a disposition report whenever you destroy stuff like working papers. You can do that once per year, and you file it with the Secretary of State's office. And in the packet that we sent out, I included both a blank disposition report and a sample that Austin and I worked together to provide you guys so that you would see what that might look like. Anything on that I should have hit that I did?
This policy used to be one, I see a lot of faces up there that a lot of folks that I've talked to about this one. It used to have a section in there, and this goes back to what Karen was saying about whether you use GAFE or 365, or you still have a hosted server like through the service unit or even on site. But it used to require you to put in there how long you're going to keep emails, digital records with their metadata intact. And I talked to a lot of you about that's because of a federal rules of evidence issue. So for those of you who have recently talked to your tech folks, bring this back to them, because you'll see that that option is really only contained in what Karen has outlined as option 4, because the other systems that are available out there, which is the issue that you run into, figuring out how long do we keep emails, for most of you that is probably forever now. And so we've tried to better account for that, which was a very common question when people were going through this policy initially. So that's more just for those of you who have been through this fairly recently. This is hopefully addressing that concern, or that kind of quirk in there that didn't make sense when you keep emails for longer and you don't have a big, deletion time period like you used to on a server.
This policy was originally written back in 2007 when they changed the Federal Rules of Civil Procedure. You guys probably remember that, when there was this big freak out about whether or not we needed to have a second server to keep copies of all of our emails. With the advent of cloud-based storage, we actually probably do keep most of our important electronic communications indefinitely. And so this revision, I think, does a much better job of addressing the realities of what technology actually looks like today than the old one, I hope. We did a webinar on records and Schedule 10 and all that stuff this past spring. We've had a lot of requests from like your office staff and even special ed and building staff to redo that. And that's another one of the statewide webinars that we might try to get scheduled to do again next year. Okay.
Next one is 3025. This is one, again, that is not, there wasn't a statutory change, but we had several schools whose auditors, whose individual school auditors, not the state auditor, said to them, you know, you really should have something for outstanding checks in your policy. At least somebody who goes through and makes sure that any outstanding checks after a certain amount of time have been reviewed. And so what we did is add a section of this policy which just says the superintendent will review any checks that haven't been cashed, basically, and we'll make a decision about how to resolve them. So that could be canceling them and reissuing. I know a lot of banks have, you know, different time periods that they'll honor an outstanding check, and that varies to some extent based on state and federal law too. So this is just a simple addition if you want it, which gives the superintendent the authority from the board to handle those outstanding claims issues. Because the board's already approved the claim, right? Because you've written the check. So it makes it so you don't have to necessarily go back to them to finalize some of that.
This is me again, school safety and security. Two things in this policy, and then a third thing that's come up since this policy went out that I just want you guys to be aware of. First thing is your policy on student memorials. I know that, you guys have followed the news. Several schools have kind of gotten taken to task in local media or even the World Herald because they turned down a request from a family to have some sort of memorial for a student who tragically dies while they're enrolled at the school. I've been through this a bunch with Jolene Palmer. I've also been to several workshops put on both for national school attorney groups, and I also went to one put on by the Secret Service years ago. And the best psychological advice is still to not allow student memorials for a bunch of reasons. One, we don't know what the emotional health is of the students that are forced to walk past that memorial every day. We don't know how they're reacting to the student's death, but we also don't know, like, kids who may have had another family member tragically die or whatever. You just don't know what trauma kids bring with them to school, and they don't have a choice to not be exposed to that because of the mandatory attendance laws. The other problem that comes up is with student memorials, if you have like somebody that dies in a car accident, that's tragic. The next kid commits suicide. Well, you don't want to glorify suicide, but now you're like memorializing one family's tragic loss and not another family's tragic. I'm telling you, it turns ugly really, really fast. There's a school in Colorado that had started a process where they were going to do like a memorial if you died in a car accident. And by a freak coincidence, they had over the course of like 4 years, 20-some kids die in car accidents. I mean, they had to like add on to the plaque. I mean, that got weird and creepy too. So for a bunch of reasons, I do not think that permanent memorials are a good idea, and that is backed up by some pretty solid psychological research. The problem is, if you haven't talked to your board about that, and you're telling them for the first time that their policy doesn't allow a memorial while there are weeping parents in front of them during public comment, that turns into a crap show. So we want you to talk to your boards about this. So what we've done in this policy is now we've given you two options to consider for memorials. One is just, we don't do it, period, the end, and the board is a bunch of hard asses and we're not gonna change our minds. And if your board is down for that, I'm perfectly cool with that. The other says, if a family is really wanting to have a memorial, we're going to work through our crisis team. And then you can see in that policy, I've kind of laid out a rubric of all the factors that the crisis team is going to consider in deciding whether or not they would recommend that the board make an exception to its general policy to not allow memorials. The criteria that are listed there are kind of designed to drive the crisis team towards deciding that they should not recommend that the board make an exception. But at least we've laid out what the factors are. And then in that second choice, if you take it to the crisis team, if the crisis team recommends that the memorial, that an exception be granted, then the person asking for it has to go to the board and ask the board. So it's like a two-step approval process. First the crisis team, and then you take it to the board. So, but I do think you and your board should visit about this summer. God willing, none of you will have this come up, but it happens, and it's so much better to have talked about this before some tragic situation is happening. Tim and I did a workshop for the ESU NOC people, the network administrators, and we were talking to them about some of the issues like with security footage and other things that happen in a crisis situation. And it occurred to us that we had not included IT staff on the list of who would be included in your crisis team. And we should have, right? Those are the people that are going to be deciding when to flip the switch to let the police have security footage if there's an active shooter. They would be like managing the email resources if we're talking about looking into a staff member that's had some sort of mental break. And so the second revision to this policy is to add IT staff to your list of folks on the crisis team, and that just makes sense to me. So those are the two changes in the policy. Last thing I'm going to mention to you, and we'll probably follow up with some sort of email communication. Jolene Palmer is telling one of our client school districts that anytime a student is suspended or expelled, the school security protocols requires the school to email the entire staff and tell the whole staff that the kid has been suspended or expelled. Like, so that, I guess, so that teachers know that he shouldn't be on campus. So if he comes with a gun because he's mad that he got bounced. I don't think you can do that. I think that's a violation of FERPA. It's not consistent with what my understanding of what Jolene and I had talked about before was. So I have a call into Jolene. She's great to work with, and I've had good conversations with her. So I will follow up with her and find out the answer, and then we will push that out. If we have to amend this policy, we will, but I don't think we do. But I wanted to say that if one of the folks that's doing the security audits comes to your building and tells you that you have to include that in your policy, I don't think that's true, but I will follow up with Jolene and get that answer for sure. So that's it for safety and security. Data breach.
All right. The next is a small revision to policy 3047 for data breach and response. LB 757 updated the data protection statute in Nebraska to include wording that the district will implement and maintain reasonable security procedures and practices that are appropriate to the nature and sensitivity of the personal information handled by the district. So I think it's telling that it's procedures and practices. You can't just install, cybersecurity software and call it a day. Every data breach that we've seen so far has a human element to it, where a tech coordinator didn't properly wipe a laptop before it got reissued, or someone's password was just left on a note. So most of the software to protect data is working fine. It's the little human screw-ups that we're seeing expose student data, and some of those penalties can get kind of stiff if it's a free and reduced student lunch. That's actually a criminal penalty. There's a $1,000 fine or a year in prison if they decide to prosecute you for disclosing that information inappropriately. And I know it might be one of the worst kept secrets in the district, who's on the list and who's not, but it is a protected information under federal law, and the state law is now backing that up with not just policies, but practices and procedures that you're going to have in your staff. So as I say in the memo here, that adapting the policy is going to be step one, and then we're going to need to follow that up with proper data protection, and then make sure those practices everyone knows to not leave their password out on a sticky note, and how to wipe computers and make sure those are being followed, especially if you have a one-to-one program, or if you recycle staff computers into one-to-ones for any reason where students get their hands on those computers. Obviously those need to be wiped appropriately.
There was a great, I tweeted it, a great example of kind of this social hacking recently. It was like a little Facebook poll. Find out your royal wedding name. So what's your mom's maiden name? What's the name of your dog? What's the name of the street where you grew up? And so it was like basically a phishing scam designed to get all of the stuff that we all use for our passwords. And they were packaging it as to get your royal wedding name and an address or something like that. And so talking to your staff about good password hygiene is important, and having your kids' birthday as your password is just not great data security. So there's that.
All right, brings us to policy 3048. When Karen and I started practicing school law, this type of policy was all the rage. There was the Ryan White stuff, and many of our administrations and boards worried about AIDS and HIV. And so these policies were all over the place. Over the years, many of these provisions got included in procedures through the health nurse or something like that, or they were included in other policies. So we've decided to remove this policy from our service. Several of you have called especially this past year, and said, hey, Steve, we have Bobby Truey coming in doing in-services in our district. We absolutely have to have a communicable disease policy, separate and distinct from anything else. And so, we put this back in. And it is different than the old one that we had. It addresses what the definition of a communicable disease is, and it follows the regulations from the Health and Human Services from Nebraska. It addresses school attendance and participation in activities for those that have a communicable disease. It provides for universal precautions and procedures. There's also a confidentiality provision. This isn't information that we obviously broadcast to everybody. We're going to give this out on a need-to-know basis. There's a staff training provision so that they understand all of the provisions in the policy and what they're going to do when they encounter a communicable disease, and then a reporting requirement for when we learn for the first time that somebody may have this. And so all of those are addressed. Policy is not required. If you don't address these issues, though, in other policies, or if you don't have procedures already adopted, you might want to give serious consideration to adopting this one.
Carol Tucker at the Department of Ed, who's the school nurse contact, she is jointly employed by DHHS and NDE. Will tell your school nurses that it's best practice to have this policy. And once those nurses get something in mind that they have to have it, it's really hard to tell them no. So this will make Carol and your nurses happy if you adopt it.
All right, I think the next one is policy 3049, which is a new policy. We had been sort of sitting back and figuring out what they were going to do from the federal level, if anything, with respect to drones and other unmanned aircraft systems. And so what we did is put together a policy which I think is consistent with how we view the purpose of policies, which is for it to be useful and something that you can actually look at and figure out, okay, here's how we should handle that issue if it comes up. This policy is not required. I know the Perry Law Firm and the School Boards Association, I think, have put out drone or unmanned aircraft policies in the past. There's nothing in state or federal law which says you must have one. I think it is a good idea. And so this year we decided that we'd put one out through our service as well. And essentially it funnels everything back to having to get permission from the superintendent. The idea being the primary purpose of it is to say then, if somebody's flying a drone over school property without the superintendent or the superintendent designee's permission, we can call law enforcement and say that person is trespassing. And we don't then have to worry about them making unauthorized recordings, recording student activities and those sorts of things. So the policy is, I think, hopefully fairly straightforward and basically requires a permission basis for those uses, both that are school uses and that are not school, that are private uses of drones on school property. So if you have somebody, for example, if you're one of the schools that has Karen's husband, David, as a local community member, and he volunteers to use his drone to film football practice, you should be thinking through, okay, is that a school use? Is it a private use? What permissions do we need to have in place? What is David doing with the video? That's why rather than try to have a 20-page policy, which contemplates what we think you should do with all that, it's really going to be situation specific. So we just kind of kick it back to the superintendent or his or her designee to analyze consistent with your other records and access policies. So that's it. It's not required, but I think it probably is a good idea if you are using drones or somebody has asked you for permission to do it on school grounds.
All right. Next is another new policy. Policy 3050 is technology in the classroom. So we've got a lot of questions about Google Home devices or Alexa Echo devices being brought into the classroom. So we want to have a policy that governed how teachers could bring those in, and that's going to implicate some federal laws. So the Children's Online Privacy Protection Act isn't really written for schools, it's written for vendors, but the school is often put in the middle between the vendor and the student. So a lot of those recommendations or the guidance surrounding COPPA says that districts should have a whitelist of all accepted apps and devices and a blacklist of banned devices and applications. We find that not to really be workable because I think the approval process for any application could take a long time, and you'd have to have a whole subcommittee meeting from your board, or you'd have to do it. And it's just generally not a workable idea, and it's not required. It's a suggestion under the COPPA guidance. So what we've done is try to make it so you're not going to have a whitelist and a blacklist, but you're going to have a list of every device and application that's in the district. And this is going to fold back into the data breach policy a little bit. If there is an application that's breached, and we see these headlines over and over, like so-and-so lost 500 million people's information, if that app is running in your building, we want to know about it so that we can notify parents if we have to under the data breach laws. So the technology in the classroom policy is built to allow your teachers to bring in Google Home devices, the Alexa Echo device. Kids can play with it. Obviously, there's definitely good pedagogical reasons to have one in the classroom. It's a lot of fun for kids sometimes. But it also says that we're not going to maintain that record. We're not creating an education record. When Amazon wants to delete the Alexa records of the wake words, when you say Alexa into it, Amazon's going to delete it. If any of you have Alexa devices in your rooms right now, I'm activating them, and I apologize about that. I didn't really think that through before I just started saying that word. But the policy is pretty straightforward. It's just a list of running applications and devices that are going to be active in your classrooms. And it also touches on assistive technologies, AngelSense and similar assistive technology for special education students can have a listen-in feature or a recording feature, and this policy requires that that be disabled. We're pretty sure that runs afoul of wiretapping laws here in Nebraska, and we just don't want them recording other student activity and violating the students' privacy there in the classroom. So obviously assistive technology is really important. We want students to have access to that, but that's got to be limited where they're not recording and parents aren't having listen-in opportunities to other students in their classrooms, and this policy deals with that as well.
Two other things on COPA and educational apps. First off, if you have a staff that comes back from, they come back from ISTE and they're all fired up, or they go to a NETA conference and they want to use all these apps in the classroom, this version of the policy lets classroom level teachers make decisions about whether to deploy apps. But if you're going to do that, I think you also have an obligation to train them, which is why we've included a link to that video from the Privacy Technical Assistance Center. It's 9 minutes long. It's not horrible. And if you just push out and say anybody that wants to be able to decide for themselves what apps they're going to use in their classroom has to watch this video, I think you're covered. If you want to do a whitelist, blacklist thing, and you just don't have the administrative resources to do it, Omaha Public Schools and Lincoln Public Schools is doing a whitelist, blacklist. I know that Omaha Public Schools has offered to share their list. So if you want to reach out to Keegan Korf or give me a call and you want to just let OPS do the heavy lifting, and then you say, we follow the same whitelist, blacklist protocols that OPS or LPS does, you certainly can do that. My fear is that no one's going to really comply with that because your teachers are just going to go and say, hey, this is cool, Quizlet, boom, we're going to put it in the classroom, which is why we've drafted this the way we've done it. Okay.
So the next one is policy 4012. This started out because we've been getting questions. Last year we passed a policy numbered 3044, but essentially it was the acknowledgement under our Political Accountability and Disclosure Act that everybody, from board members on down to paraprofessionals, may have been accessing Facebook during break times on school computers. And while that seems like kind of an obvious thing at this point, the Political Accountability and Disclosure Act requires you to either specifically authorize that or leave yourself up to chance that it's going to be considered a de minimis use of school resources. So what we did is put out a policy which says, here's how you can use those resources. Our policy 4012, which has long been the staff internet and computer use policy, did not really distinguish between on-duty and off-duty use, which I think is important for First Amendment reasons, among many others. So without going into a ton of detail and telling you about the very lively debate we had in our office about this policy, suffice it to say that we tried to come up with some category headings that do a little bit better job of talking through acceptable uses, acknowledging that a lot of staff members are taking your devices home now, that we don't have 2 cell phones and 2 computers anymore. It's sort of just a kind of a homogenous one. And they might be looking at Facebook at home. Is that different than looking at Facebook while they're on school grounds? Is it different than flipping through Facebook while, we're at halftime of a basketball game and they go to their room real quick? So all of those, where they're doing it, how they're doing it, questions are legally interesting, but I don't think we need to get into the weeds. If you take a look through the changes to that policy, hopefully it will make sense how we're trying to draw at least some lines of demarcation for staff members who we know are accessing the internet and using school computers and those sorts of things. Personally, professionally, on school grounds, off school grounds, all of that stuff. So again, there's a reference to policy 3044 in there. Those two should now square up a little bit better for that purpose. Well, since we can't, these kids these days, right? Karen and Steve just can't keep them off their damn phones. So the next one is policy 4013, and that's our standard grievance procedure. We've talked a lot about this. I see everybody up there's probably been to a presentation this year where some school lawyer has talked about the Clarkson College case, which was basically the requirement that if you have a grievance procedure available to you, which is part of your employment, that case wasn't about employment, but basically if you are under contract and part of that contract requires you to exhaust a grievance procedure before you move on to, for example, filing a lawsuit, you can't just skip that process. You must actually go through the grievance process. So that led to a lot of discussion among school lawyers. We've had discussions with the NSCA attorneys about, holy crap, are we going to get a bunch more grievances now? Because every single slight that we may eventually escalate into something like a lawsuit or a CIR complaint, we've now got to grieve. Well, I don't think we've had the huge influx that we were
We've
first
had a few,
afraid of.
but not as bad as.
Yeah, I don't think so. I mean, maybe some of you are like, yeah, Bobby, we've had 20 this year. We've only had one in the last 10. But I don't think we've at least gotten a lot of calls on an influx of grievances. Part of that, I think, is actually this case working, which is that rather than just complain about it on Facebook, they actually are forced to bring it to somebody who can address it. You misplaced me on the salary schedule. I turned in my education hours, and the bookkeeper just forgot to move me up. That's something that we anticipate handling at the direct level. And so we would say that that's the grievance process working, not that it's being invoked when it shouldn't be. So the first thing to consider if you haven't talked to your board about it is language that makes our grievance process mandatory. All of you may remember negotiations this past year. If you were negotiating and weren't on, flipping over to the second year of a 2-year deal, you probably had the union bring you a proposal to insert language which said something like, our grievance procedure is discretionary. It is not required as a component of exhaustion before filing any other sort of claim or complaint against the district. We recommended against taking that language that the NSCA proposed for this specific purpose. So this policy was changed a little bit to kind of give a nod of deference to some of those issues. But more than anything, we just wanted to raise the issue again so that if you haven't talked to your board members about it, you can. And the other thing that we did in here is added basically at the end, that comes to fruition with the requirement to grieve provision. So many of you don't actually use this policy, but instead have taken it and put it in your negotiated agreement. We think that's the right step. If your board still believes that if we have it in policy, it's somehow super secret and protected and they still have to comply with it, and we don't have to negotiate over it, tell them to get rid of that understanding. Your grievance procedure is a mandatory subject. What I think this allows you to do is, if it's not in your agreement, put it in there, but also forces the discussion about whether we are going to require people to use our grievance procedure. The last thing it does is very similar to the complaint procedure in 2006. It adds a provision for bad faith or serial filings. So you think staff members are filing grievance after grievance just to piss you off, to create a bunch of administrative headaches. The principal didn't buy me those pencils that I want, and so now we're going to go through a full board hearing on that sort of thing. If you think they're acting in bad faith, this gives you, again, the ability to sort of short circuit some of that. So if you have any questions about the Clarkson College case, the case that says if you want to make it mandatory, then they have to exhaust it, let us know. But we put a nod of deference to that into this grievance procedure, which again should either be included this next negotiation cycle if you have it in your agreement, or if you still do have it in policy, we recommend making that change even though it's not legally required.
This is me, right?
Yep.
4014 is next. It's just a few small revisions to the employment-related sexual harassment policy. One is we reiterated that employees can either use the complaint procedure in 2006, or they can go directly to the Title IX coordinator with their complaints. Now, the complaint procedure says that you can jump straight to the Title IX coordinator, so this is more of a belt and suspenders approach, just making sure that in the policy that explicitly covers employment-related sexual harassment, that they're aware that they don't have to go through the formal process. If it's a sensitive issue, they can go directly to the Title IX coordinator. We also removed that you could report directly to a board member, and that's because we saw some court cases where a board member was aware of the sexual misconduct that was going on, but never brought it to the administration's attention, and that fact was used against the school district when they were deciding whether or not the school district was deliberately indifferent to the situation that was happening within the district. So the board member as someone you can report sexual harassment to, we eliminated from the policy, and I think that is a good change. It's not required legally, but I highly recommend it because I don't think you want board members handling these kind of complaints. And we want to make sure that staff know they can go straight to a Title IX coordinator if that's something they want to do.
I think I am next on 4047 because this was my screw up. Last year when we did the safety and security updates, we moved the policy on student assistance teams from the employment section, which is section 4000, to the student section, which is section 5000. That just makes more sense. We had it in 4000 years ago because we used to fight with teachers about whether or not we could force them to be on the student assistance teams. But that's, I mean, anyway, it makes more sense to have it in 5000. So we moved it, but we neglected to tell you to delete this. So this is just, we're not getting rid of student assistance teams. We're just making sure that it doesn't exist in 2 different places in your policy book. I think I'm also 5008 pregnant and parenting students. We were ahead of the game for once, so yay us. We had a pregnant and parenting policy sent out to you guys last year with the updates. And then some of you probably saw from your service unit an email that said, don't forget you have to have a policy in place by May 1st. The Department of Ed came out with its form policy shortly before. It was like in early April, I think. After the department came out with their proposed policy, I sent our policy that we'd sent last year over to Sarah Hulak, who's the attorney at NDE that put their form policy together. She had some minor tweaks that she wanted us to make, and I said, sure, we would recommend that. So some of you might have already adopted this revised policy before May 1st. If you didn't, this is just a small tweak that you should make when you adopt these updates. Oh, 5017 is me too. I was standing on the football field for my son's senior night and realized that they were announcing every kid's name. And I was like, I wonder if Norris has parent name in the directory information policy. And I came back and checked, and our form policy did not have parent name in directory information. So I can't believe we've missed it until now. This is why I like this model of having a service. So when we think of stuff like this, we can change it. But if you ever announce the name of a kid's parent, you should include parent name in your directory information policy. And so that's the tweak that we've made to 5017.
All right, 5026, we touched on a little bit with the 2006 complaint procedure revisions. But basically what we did is we folded 5026 and 5027 together. So it's now sex discrimination and sexual harassment of students. So it's kind of a victim-based approach. So if you have someone that has an issue, instead of figuring out who harassed them or who discriminated against them, they just use this policy based on who the victim of the discrimination or the harassment is, instead of trying to figure out who the accused party would be. The reason for these changes also stems from Department of Education guidance changes. They removed new guidance that came out under the Obama administration. So that letter was rescinded, and they were going back to a 2001 letter from the Bush administration to govern how Title IX is handled. They have a Q&A document, and we've made those available online, and we'll link to those again on our website. But basically, you have the standard of proof issue that we already addressed, the preponderance of evidence versus clear and convincing evidence. And we recommend the preponderance, just have a blanket standard for everything. But there's also an appeal issue that the Department of Education recently brought up. And that is if you have a complaint where you're alleging sexual harassment or sexual misconduct, sexual assault, anything, and the investigation shows that there wasn't any, the person making the accusations could appeal that. But the person accused never had a way to appeal if they were found guilty of engaging in sexual misconduct on school grounds. The new guidance says that they have to be able to appeal as well. So both parties, the accused party and the person making the accusations, are going to be able to appeal that under the current complaint procedures. So 2006 was modified to handle the appeals process and the standard of evidence required by the new Department of Education guidance. And that folds into how 5026 works, where it lists disciplinary decisions at the bottom of the new policy. So the new edition, section 3, disciplinary decisions, walks through decisions to take disciplinary action. And those are all based on the standard of evidence established in policy 2006 and the appeals process established in the complaint procedure 2006. So it's just trying to keep everything simple and focused on one complaint procedure for everything. We just had to rejigger some things under the new Department of Education guidance to make that functional.
To me, at least.
Oh, and then this one is me as well.
Yeah.
All right. So 5035 for student discipline, this was revised to reflect changes in state law. LB 1081 was passed, and it includes a requirement that you collaborate with your local district, or with your local county attorney, that the school district collaborate with the county attorney on what offenses and what violations of school rules need to be reported as violations of the law. So instead of enumerating all the different laws that a student could break and probably does break, like a school fight, for example, that's an assault. Instead of going through that way and saying which violations of law, we've categorized different violations. And some of these are going to be required reports under different state laws anyway. So if you look at the bottom of 5035, it now has a reporting requirement to law enforcement. And this change will be updated in the handbook as well. And the categories are pretty straightforward. If the violation of the school rules or the student conduct policy involves possession of a firearm, we're going to report that to law enforcement, obviously. If it results in child abuse, you already have a mandatory report, so we fold that category in. If it's a violation of state law that the administration believes cannot be remedied solely with school discipline. So that's where we've given you the most flexibility. So if you think school discipline is not enough, you can report it to the county attorney or to law enforcement. If it's a violation of state law that endangers the health and welfare of other students, if it interferes with school purposes, or the report is required or requested by the county attorney. So let's say your county attorney actually gets back to you to collaborate as is required under the law. Anything they request, obviously, we're going to report to the county attorney. So we've tried to create these broad categories instead of walking through the criminal code line by line. And we've also tried to give you the most flexibility on what you're going to report to the county attorney and what you aren't. The form section of the website, along with the 5000 series, also is going to have a form letter that you can send to your county attorney saying that the collaboration is required under state law, requesting that they collaborate, and you attach this policy to it. And if the county attorney signs off, we've collaborated, and you can move forward with kind of the broad categories that we've identified. And if they do actually want to collaborate, you are going to be bound by what they want reported to them, because the policy states that anything they request reported obviously gets reported over.
This is obviously a tremendous pain in the butt if you are a school that has spans multiple counties.
Right.
It's kind of like your mandatory attendance policy. You have to send a letter to the county attorney for each county that your district covers, saying, here's our proposed policy. If you want to get back to us and have a conversation, you're welcome to do that. And then you can check the box that says you collaborated. Do you want to mention the?
Yeah, just a couple things to add really quick. So this is the one where you call and we're talking through it and we stop you in the middle and say, have you called law enforcement? Because technically that's a violation of state law, right? We had a shoving match in the lunchroom. As Tim mentioned, that's an assault. Under the way 79-293 is written, if it could constitute student discipline, and it is also a violation of the criminal law, you have to report it. So rather than thinking of this as changing or somehow expanding what you have to report, it's actually limiting it more. So law enforcement should have been getting calls from all of you, and many times they probably said, Dana, why in the heck are you calling me on that? I don't care because he stole a box of pencils out of that kid's locker. Like, I'm not going to criminally charge that. Why are you wasting my time with that? And our answer was always, gee, look at 79-293. It says I have to report that to you. In talking to Brian Halstead about this, and I think this was kind of his brainchild, I don't mean to speak for Brian. I know he'll be talking to you guys about this at the school law update coming here in a few weeks. But basically, Brian said a lot of schools are already talking to their county attorney about what that county attorney wants reported to law enforcement. This is modeled after, like Karen said, the mandatory attendance laws, where you're supposed to speak to the county attorney about, when you're going to make reports of students who are absent. And, is it after 20 absences? How many have to be, unexcused versus excused? You already have to collaborate with them. The idea, I think that they had at NDE was this would allow you to more closely refine the list of times they want you to report. The problem is, as I raised with Brian, that means we could have 93 separate reporting standards. There could be some county attorneys who say, I'm not going to prosecute kids who are sexting. Don't call local law enforcement with that. Technically, that would be lawful, I believe now, under the way that this is written, because it's changed your reporting obligations for it used to say any crime, basically, any violation of Nebraska criminal code. But some of you may think, well, gee, that's a little bit risky to not report that kind of thing. This forces you to have that conversation. So what Brian and I talked about was at some point, maybe coming up with a list of like, okay, all of these have got to be reported. And either NDE including that in a regulation, or kind of helping drive it out through the policy model where maybe we could collaborate with the County Attorneys Association. And so maybe school lawyers and county attorneys could talk about this, but this issue is probably not going away. I mean, obviously you're supposed to report all this stuff anyway, but we're hoping that with some continued collaboration with NDE and with the County Attorney Association, we can actually make it much clearer what you're going to have to report. The other thing that Brian mentioned to me, which is a really good point, is if you're going to put a policy like this out, our recommended version, for example, that's going to require some pretty significant training for your building principals, because this is going to change how they have always thought of it, or at least it should change how they've thought of it. So if you are going to have this in your policy and it becomes what you're going to send the county attorney, number one, you do have to send this to the county attorney, as Tim mentioned. But number two, Brian says you should train on this for fear that if you don't train principals, there are parents who could file complaints against them for failure to comply with district policy on reporting. So seems obvious. I'm sure you're probably all thinking, wow, I better get this in the hands of all principals too. But that's one of the things Brian mentioned. So I think that's pretty much everything, unless.
The only thing I would add is what this policy looks like in practice is really going to be dependent on your county attorney. I see Mark Adler on the webinar. You know, Douglas County is like, they want everything reported all the time, which is crazy to me. As opposed to Mark Sievering, who I see, Mark, your county attorney doesn't want all that stuff reported. So the idea that you collaborate out with your county attorney is important. I personally don't know that that's all that just. It feels unjust to me that the school discipline is different depending on where I do the bad thing. But I guess that's just the reality of local control. And so communicating with your county attorney is an important part of this.
Yep. The revision in policy 5037, this is actually a great example of how you guys make the policy service better. Jeff Smith at Oakland Craig had sent me an email and said, Steve, this doesn't make sense. And what it said was, students shall not use email, chat rooms, instant messaging, or other forms of district electronic communications on school computers, period. He said he was kind enough to point out, Steve, that's kind of all they do on those computers. And so we obviously had taken something out or missed something during a previous revision. And so we've just made clear that they can't do that for unauthorized or unlawful purposes or anything that's in violation of school policy or school law. So again, thank you to all of you. I mean, I know Bobby and Tim take the brunt of this, but you guys calling in and saying, hey, this doesn't make sense or this isn't how we do it, does make our service much better because it helps us think through things that we didn't think of when we originally drafted. So thanks for pointing that stuff out.
This next revision is very similar to what Steve was just talking about. We were working through a student fees question for a district, and while we were walking through the elective course materials, we revisited the student fee statutes, and we revised this policy based on that. So previously, if you had an elective course, like an industrial technology course or an art course, the students were going to buy the materials, and then you would cap that based on how high that could go for the semester. But student fees for elective courses aren't specifically authorized, and even though the courses are elective, they're not going to be considered an extracurricular activity. So there's going to have to be some base level of coursework that they can do without being charged any fee. So you can have them build a little pine birdhouse, and if they want to get white oak and build a chest of some kind, they can definitely do that, and they can purchase the materials through the school or with a vendor that the school has approved, and we can supply the order forms, and then it's not even a fee. It's going to fall under the school store statutes. So you don't have to put it in here, you don't have to index it, it doesn't have to be capped as a student fee. They're just going to be purchasing something through the school. But there does have to be a base level of art supplies and industrial technology supplies that students can use to complete the coursework on their own without a fee being associated. So the policy has just been updated to reflect that change.
Next is 5054, which is bullying. A couple of things. I really would just please share this policy with all of your building principals. Whether your board tweaks it or not, this is one that I think it's important that the whole administrative team have a common understanding of. What we did is we have inserted two different definitions into policy 5054. The first is the definition used by the Centers for Disease Control, which is the one that when I've come out to your schools, or Bobby's come out to your schools, or Tim's come out to your schools to do digital citizenship, it's the definition that we use with kids and parents. because I think it's the most useful definition out there. It's also the definition that I think the courts are going to use against you if you get sued in federal court. And then we also include the definition of bullying in the Nebraska statute, which is skinnier, but obviously we're also required to work with Nebraska law. So we have both those definitions in that first paragraph, and then we say the administration is going to use both of these definitions to determine whether any specific incident of student interaction constitutes bullying. So hopefully that gives you guys maximum flexibility to figure out whether something qualifies as bullying or not. The next section just says kids aren't allowed to bully. Next section, so many times we get phone calls from school administrators that say, the students were sending mean Snapchats to each other. This all happened over the weekend. She's in my office crying because they called her fat repeatedly, but I can't do anything because it didn't happen on school grounds. And it is true that under the Nebraska Student Discipline Act, you cannot long-term suspend or expel a student for misconduct unless that misconduct occurred on school grounds, in a school vehicle, or at a school activity. Now, we can impose other discipline on kids. We can keep them after school. We can have them write a paper on how bad bullying is. And so this, you can kick them off the volleyball team if they've been tweeting about how fat the speech team is. All of those are things that can happen. And I see principals really struggle with the idea of what can I do if this all happened off campus. So this next section is our attempt of explaining both to parents and to principals about what disciplinary consequences we can impose based on where the bullying activity occurred. The thing I'm kind of worried about is I'm seeing a trend, especially in the special ed context, of parents saying, yeah, my kid was repeatedly bullied and it all happened off campus, but because they called me a retard on Snapchat all weekend long, I was unable to academically perform in my classes when I came to school on Monday morning. And the school knew about that and tacitly approved it because nothing happened. So if someone's being bullied based on their protected class status, like disability, race, sex, you might have to do something to protect that kid, even if you can't expel or long-term suspend the bully who was being mean to the kid. Even if the kids from, I'm looking here, if somebody from Valentine is cyberbullying somebody from Cody Kilgore, Adam might have to take action to protect the kid from Cody Kilgore to deal with like the educational fallout of that, even though he can't discipline a kid from Valentine for being mean to the kid. So that's what this next section is designed, these next two sections are designed to do, to say, even if we can't punish the bad guys, we might have to take affirmative action to help a kid that's been targeted to deal with the consequences of that if that is creating an adverse educational experience for the victim. So separating out in your mind the idea of discipline for the bully and support for the victim is important training-wise for your admin team and for your parents to understand. And also, I think, important for you to understand in terms of your affirmative legal obligations. Last thing, you're required by your E-rate application to have bullying prevention and education. If Sue Ann Witt or somebody that's doing an E-rate audit shows up and says, where is your stuff on what you're going to do to comply with your FCC obligations for E-rate, you're going to want to pull this bullying policy. This also complies with Rule 10. And this is one of those policies that you have to review annually. So, sorry, I said way more about bullying than I meant to.
We just wish you'd read some of what you actually write, because you should try working here with her for a week. All right, next policy, 5057. This is Title I. I see a lot of faces up there again that have been through your Title I review or audit recently. A few years ago, we've always tried to do it, but we tried to be much more deliberate. You've heard us mention NDE representatives several times. We sort of decided that if they're going to be the ones reviewing the policy, let's reach out to their program level coordinator type of folks, not necessarily even the attorneys over at NDE every time, but figure out, okay, if you're going to send somebody out to a school with the Title I audit checklist, what does our policy have to say to get you to say, yes, they'll meet everything that's required? And so, Mark, I see you up there. I see several others who have been through a Title I audit. And so what we did is earlier this year worked with Kathy Monarchy at the Department of Education. And it's, right, wrong, or indifferent because of ESSA. We've had changes the last 3 years, I think. And we'll continue to every year that they decide to make changes. collaborate with them. But I didn't put anything else in here about what actually changed. What I can tell you is we've, tried to work with them to write things that are both required, but don't promise a bunch of stuff that isn't required, even if they would love to see that in there. And so we did get NDE's blessing on our updated Title I policy. It includes, for example, an actual change to the title of the policy. It's no longer parental involvement. It's now parent and family engagement. And so those sorts of things, they actually have to see to report back up to the feds. And so we've, again, every change that was made in this policy was specifically because of simply changes to how they view the audits of this policy. All right, 5062 is another version, another policy that we've changed. If you don't have this one, for example, if you're an updates only subscriber, now you have it in full. But the reason that we changed this one is because we had two options in there. We had an option A and an option B. Well, option A included NITS, which is a big, if you ask your school nurse whether we should exclude students on the basis of simply having NITS, that is going to be a kind of a hot topic, controversial discussion. But we believe that there's no prohibition under the Health and Human Service regulations for that. But the problem is when we were copying and pasting option A and option B, the option B, which was supposed to exclude NITS, had a reference to NITS in there at one point. So this policy is now updated. It's clean to include the full option A, option B. If your board picked one of those in the past, and in particular, if your board picked option B, where we're going to allow students to attend even if they have NITS, as long as they don't have any live lice or louse eggs, you should revisit that because there may be an accidental reference, which is totally our fault, in there that again references NITS in there. So that would be, that's the only change in there. It's kind of confusing. There's nothing substantively that changed with respect to how you're required to handle or address licensed NITS.
Every time we talk licensed NITS here in the office, I have to touch my hair because it grosses me out. Next is a revision to 6021. When NDE revamped their website, the URL changed and the URL for service providers changed. So we just fixed it, put the right URL in.
6031 was an emergency exclusion. That one too. All of these last three were catches by all of you, which we really appreciate. And frankly, there's no real pride in authorship here. We're not afraid to admit it. So if you see anything stupid, congratulations. We'll change it for next year. Just let us know. But this was one where we simply had made a change, but the red line or for whatever reason didn't get saved over. So we had a sentence fragment, and that's now been updated. So 6031 is, again, a very minor change.
6036 is a brand new policy. Yay, more responsibilities for school, no extra money. They have implemented the Nebraska Reading Improvement Act. And essentially the intent is to make sure that all students are reading at or above grade level by 3rd grade. And so what does this mean for us? It does require you to develop policies to address the various issues in the bill. This does not begin until the 1920 school year. But you're going to be required to administer reading assessments that have been approved by the Nebraska Department of Education 3 times per school year for all kids in grades kindergarten through 3rd grade. You're going to be required to provide supplemental reading intervention programs to those who are identified with reading deficiencies. And there's also a provision that says NDE can adopt rules and regulations. When I called over there and asked them, had they adopted these yet, Brian Halstead laughed at me and said, "Are you kidding me? It just passed." And it doesn't even go into effect for a school year. So it might be a little while before they get the rules and regs out. But if they put anything in that requires us to change our policy, obviously we'll do that. This is a required policy. This is one of those weird things where although the rules don't kick in until 1920, all the policies, unless there's some different effective date, are going to go into effect July 19th. And so you need to have this policy in effect, even though it won't kick in until next school year.
All right, so that's it for the policies. Yeah, what we were talking about here is, should we stop real quick and take questions? We're just going to try to get through the forms so that those of you that don't have any questions can bounce off the Zoom here, and those that do can stick around. If you have one right now and you want to send it in on the chat feature, we can come back to it. But we're going to try to truck through the forms really quickly here. Our employment application was updated. There was actually a change 2 legislative cycles ago. And this was Josh Fields that actually at Seward kind of caught this and alerted me to it. I think our application as it is currently written is acceptable. It is still lawful, but it doesn't make very clear to an applicant when they are entitled to a veteran's preference. One of the main things that they changed in the veterans preference law during the 2017 legislative cycle was now including a veterans preference for spouses of active service members, no longer just those who had come back and were disabled. And so basically they expanded the number of folks who are entitled to ask for a veterans preference from you when they apply. The substance of it, what you're required to do, adding points to those who have, if you have like objective scoring criteria, all that stuff has remained the same. But we wanted, again, to make sure that it was a little bit clearer in the policy when they're entitled to a preference. I think that complies not only with your legal obligations, but makes it a little bit easier for you to figure out why you got their Department of Defense form if you did. The other thing to note here is I continually see job postings for schools that do not contain the requirement that this position is subject to veterans preference. If you've posted a job for any position at the school, and that posting has gone out so the members of the public can see it, it must include language that says this position is subject to veterans preference. If you're not doing that, write that down because that is one of the ways that they can ding you for non-compliance. And so based on the little changes and nuances they've made, the fact that more people can now apply for a veterans preference, that's gonna, I think, force the issue a little bit more clearly. So if you've never had that in your job postings, it's right there in the memo. That's gotta go in every single posting you send out, whether you're hiring a new part-time cook, a new paraprofessional, or a superintendent, that has to be in there. The next one is me, the copyright compliance for school staff document. That is a circular, it's called, put out by the Copyright Office, the Federal Copyright Office. That would be, for example, something that you could disseminate to your teaching staff members, your certificated staff members, which would allow them to at least read through something to get them thinking about copyright compliance, making copies of textbooks, those kind of things. So that's not something that like you're required by law to have. Unlike some of these forms, though, we hope it's something that you can use to serve a purpose that we've articulated in the policy. The next one is the Title I School Parent-Student Compact. That's part of the federal Title I family engagement, no longer parental involvement requirements. If you have not seen yours and it's growing dusty, I would understand that. But there were some required changes in there based on some changes to the wording that the feds required NEE to enforce when they do Title I audits. So they did take out the signature requirement. That I think could be important for those of you, especially that have like building-wide or district-wide title programs. Your compacts used to have a signature component. That's no longer required. So if nothing else, it probably saves somebody some step in there if you were complying with that in the past. So take a look at that. I think the next one, disenrollment packet, is Tim.
Yep. So for disenrollment, there's a few different statutory reasons to disenroll, and that's going to depend on age and circumstance. So the packet just has a one-page document for each one of those statutorily allowed reasons for disenrollment. NDE has their own form for 16 and 17-year-olds to disenroll, but they don't have the 5-year-old attendance affidavit or disenrollment, or a 6-year-old alternative education arrangement form. So we just made one for all situations, including an 18-year-old student who's signing for themselves. So one of the pages applies to each situation, and then there's the superintendent certification at the end of the packet if you have to conduct an exit interview, and a few of the situations call for one under statute. So it's just for easy use. This was already in the disenrollment. It was just one form. You picked and chose. It doesn't matter. You chose different sections of the form that you needed. We just created one form for each situation with a heading at the top, so you can pick the form that applies, and the parent can fill that out, and you can fill out the last page just to make the paperwork clearer. Oh yeah, and this is the letter to the county attorney for 5035 and student discipline. This is the form letter that you'll attach to the new 5035, and it'll go out to request a collaborative meeting, or at least a collaborative email exchange with your county attorney regarding which offenses should be reported under the updated student discipline laws.
Some of you don't have as good of a relationship with your county attorney as you would like. We view this letter as something that you can use to check the legal compliance, but in all seriousness, I believe they talked about this law at the county attorney conference, which just ended last week. So I know you've got a million things to do between now and your June meeting, but it might not be a bad idea to pick up the phone and call the county attorney and say, hey, apparently we're saddled with this new collaboration requirement. Would you chat with me about it? And, I think those schools that have a good relationship see better help in attendance and in crimes that occur at school. So they, I believe, have been alerted to this. I would not waste that opportunity to reach out to them in addition to sending this letter. But we think this letter checks the required collaboration box. The last form is a foreign exchange student application. Anytime in our policy we use the word shall fill out an application, shall apply, we try to have a form there for it. We did not have one for foreign exchange students. I know a lot of times the various sponsoring agencies have like a packet of information they send you, which often is considered the application. But this one has some, I think, important stuff that you're going to want to consider anytime you have a foreign exchange student notification or somebody says, hey, we're going to host one. It gives you an application used for that purpose.
Other issues to consider, I'll lead off. This is kind of a good news, bad news situation. Quick footnote. Hopefully all of you got and filled out the client satisfaction or client feedback survey that we pushed out in April. We're going to use that to make some decisions over the summer. And one of the questions we asked is, would you rather have policy updates come out in one big wad like we're doing now, or have them come out piecemeal? Right now, I will tell you, it's like 50, 45. I mean, there's no clear preference. So if you have a strong preference about when these policies come out and you haven't filled that survey out, we'd sure like to get your feedback because we're not exactly sure what to do about that. The reason this procurement policy brings that to mind is the feds have decided, President Trump changed remember the micro purchasing and you have to bid everything for your school lunch program and all the freak out that we had last year about those real tight limits. Well, Donald Trump waived it for the military starting in December of this past year. And the U.S. Department of Education has said they are going to up those limits, but they're not going to do it until after July 1st. They have not released the regulations yet. So we are going to have to update your policy 3003.1, 3004, and 3004.1. But we can't do it until the regulations come out. So you will have an update from us sometime in July or August, because I'm assuming all of you are going to want to be able to not have to bid if you're going to spend more than, I think it's $3,000 under the old regs. The micro purchase limitation now is going to be $10,000, so it'll be way higher. But we can't make that change until the regulations are out. So that's what this is. There's going to be an increase in the amount over which you have to bid, but we can't get that policy out until the feds actually release the regulations, and that's not going to happen until July.
All right, voluntary termination incentives. This actually was a bill that was passed last session. Didn't go into effect until September 1st of 2017. I think this got us more whipped up here than with anybody else. A little irritating, a little frustrating. It's still in places clear as mud, but here's the bottom line. I won't bore you with the details of how and when this works, but if you are up against your budget authority limit and your levy limit, that's when these limitations of this new statute kick in. If you are not bumping up against both of those things, you don't have to worry about these limitations. In addition, even if you are bumping up against those limitations, if you're not worried about having this outside of your levy, you don't have to worry about it either. So if you happen to be up against your budget authority and up against your levy limit, and you want to put this outside of your limits, that's when you should give us a call. Short of that, you don't have to worry about it.
If you have an ERIP policy and that's all being paid within your current limits, then all the statutory changes, basically when they used Millard as a sacrificial example last year in the unicameral, it doesn't apply. So we got a ton of questions about it. Bobby, we want to have an early retirement incentive for our teachers, but we don't. What do we have to do to comply with that new law? And we looked into it quite a bit here and concluded that for 99% of schools out there, the answer was nothing. Yeah. Because you're paying within your levy limit, so all the restrictions on how much you can pay, how many years you can spread that out, they just don't apply if you're paying within your levy and budget authority.
Child restraint is you, right?
Oh, child restraint, yes. Apparently when Karen and I were kids, it was good to you didn't restrain kids at all. You climbed from the front seat to the back seat. Now you got to strap them down and make sure that nothing happens to them. And so they've changed the rules. So this was LB 42. Essentially, we've listed the rules there, but they've changed some of the age limits from 6 to 8. They now make it so that kids under 8 have to ride in the back seat. And again, children 8 through 18 have to ride in a secured safety belt or a child safety seat. That used to be, they had a lower limit of 6, but they've changed that. And again, you've got to have these rear-facing child seats until they're 2 years old. But this was it was one of the senator's priority bills, and I expect as the federal law changes and as the studies and statistics change about how kids are safe or not safe in a vehicle, you'll continue to see updates on this. But the specific changes are listed there in the memo.
Yeah, I mean, I did talk to at least one school who does transport some really violent 7 and 8-year-olds. And so previously they didn't have to have them in a car seat. Now you do. And that's going to fundamentally change the process that they go through to load that kid in the car. So they're literally having to do retraining for the staff member that transports that student. Because anytime you throw him, in this case, out of his normal process and routine of getting buckled in, he freaks out. So I think there are going to be a few really specific examples of where this will come into play, but we kind of talked about it and didn't see it as a policy change, but more just to notify you for if you have transportation obligations to any of those kids.
Oh, we've got another one. I don't think a lot of you have used this act. There was a Public Facilities Construction and Finance Act. It was a nice little loophole that lets you issue some bonds without having an election unless enough people complained about it, signed a petition and submitted that. They've changed that, and so now if you're going to use that act and you're going to issue bonds, you have to have a vote of the people, period. There's no more loopholes that let you get through it without that. And we've seen a trend in this way. I think it was Senator Groney's bill who was trying to limit your ability to levy for the building fund without having an election of the people, and I think we had a compromise bill there. But you're going to see more and more of a push towards that way of doing things so that people have to vote on you spending money. I'm glad it didn't affect the building fund. I think that was going to be way too limiting for you guys to do things that you should be allowed to do. I mean, that's why we like board members, and that's why you guys have the degrees you have. But this is one of the areas where they have made it so that you do have to have a vote.
Next, there was a general freak out among the tech people this spring earlier about E-rate applications. There's guidance. Sue Ann Witt had sent an email out, and Sue Ann is the E-rate coordinator for the state. And I like Sue Ann. She's a pleasure to work with. So she sent an email out to the network administration people saying, like rattling off the requirements for E-rate compliance, and it kind of freaked out some of the staff members that do E-rate compliance for you. So your policies, if you are a full policy service subscriber, 5037 and 5054 should have you in complete compliance to apply for E-rate so that your tech coordinator doesn't have to worry about personal liability. The one little thing that you should know is back when you first adopted your acceptable use policy for students and staff, and this is probably going to be in the first Clinton administration when you did that, so it's a long time ago, you were required to have a hearing on your very first acceptable use policy. So go back and look in your old board minutes. If anybody's asking, that's where that hearing is going to be. But this is not one that you have to have an annual hearing for. So every time you tweak your acceptable use policy, you don't have to go back and have a full-blown hearing. But your school district did it years ago when you first adopted it. Finally, if you're doing your E-rate in a consortium, the consortia administrators have to ask for these documents. So like if you are part of a service unit that does the E-rate billing, or if you have, like a regional consortium that does it, you're going to want to push these policies and the board minutes from that hearing up to the person that's applying for you for the consortium, because they are asking for it at a consortium level. So this is hopefully much ado about nothing. I think you're all perfectly compliant, but there was some panic about that among the technical people this spring.
And the last one is just Congress passed the Protecting Young Victims from Sexual Abuse and Safe Sport Authorization Act in 2017. This was in response to the U.S. gymnastics sexual abuse scandal. This law is not going to apply to almost every Nebraska school. It's mostly about amateur sports that have interstate competitions and feed in to the Paralympics or to the Olympics. That's the goal of the law. So if your school engages in interstate competition, interstate athletics, you may be affected by some of the provisions of the law. But even then, it's unclear if schools participating in interstate athletics even qualify for the law. So you might have seen it in the news. We just want to make sure that you know that we know that we're aware of it. It's not going to require a policy change. And if you have interstate athletics, we'd be happy to look into it more for you to see if it touches your school district, but it probably does not.
The reason we included it is because several of you got an email. Some of the insurance carriers for schools sent out an email that said, holy crap, this new federal law passed. So we wanted to take a look at it. We don't, like I said, we're not including it because we think it's going to affect many of you, but we did get a lot of calls when the insurance company sent out emails saying, holy cow, this new law passed. So if your board members, for example, got it, or if you received one and you thought it had additional obligations, that's why we wanted to put it in here to let you know that we did look at it, no policy change required. So that was pretty much our purpose.
Okay, our goal was to get through these updates in 90 minutes, so yay us. I do have one text that I'm gonna answer. If you've got questions, you wanna text them to me, that'd be great. And then as soon as I answer this text, we'll unmute you all and it can be a mad free-for-all. But I had a question about 5035, which is the student discipline and notifying the county attorney about crimes that have been committed. There are schools that have kind of gotten beat up on both sides of this issue. First, why did you call the cops? Why do you have to freak out about every little thing? Or why didn't you call the cops when my kid had a fight? As the Nebraska Student Discipline Act is written, you're supposed to report under the old act any violation of the Nebraska Criminal Code, which meant your principal theoretically was supposed to be calling the cops all the time. The amendment to the statute was Brian Halstead's attempt to get his arms around what exact crimes we are going to report and what crimes we aren't. So the example that this person sent me is a physical altercation between two kids in the hallway. Can we just deal with that, or do we have to call the cops? The answer to that question is call your county attorney, because your county attorney now is going to hold the key to whether you have to report that or not. And if your county attorney says, yes, I want to criminally charge every single flippin' assault in school, then you're going to tell the parents, you know what, don't blame me, that's the county attorney's call. If your county attorney says, you know what, if it's just a shoving match over who got to the lunch line first, I don't need to be bothered by that, then you have the protection of not having to report every single thing. So that's that question that you asked is the entire purpose of the law. Now, the next thing is, what if it's a violent special ed kid and we have like the third grade parents are all ticked off because this third grader's kicking over a table every day? Is that assault? Again, this is, you can't just, willy-nilly kick special ed kids out, even if the county attorney wants you to report every crime. So placement is different than criminal reporting, but you are going to have to talk to the county attorney, and you should include in that conversation, what about little guys? And so talk through that with them.
This is the next question came from you, Mark. It's a good one. I think our student discipline policy is 6024. Did I miss changing it? A few years back, it was actually the student discipline policy was duplicated. It was in 6024 and in 5035. That was so that wherever a parent looked, either in the curriculum section or in the student section, they would find the discipline policy. It was basically a nod of deference toward making sure that they had notice. It's also obviously in your student handbook. We changed it to keep it just in one place so that there didn't need to be duplicated, Mark. So it can be in 6024. That one is now intentionally left blank. And so maybe you've got something else in 5035. But we, when we modified it, put it in 5035, and basically left 6024 blank. So I know a lot of you, and for board members especially, like the numbering matters. We don't want to be off on numbering because when you're making references, we want to not have to go, hunting for what that is. But so that's where we're going to house the student discipline policy is 5035 on a move forward basis.
Next question. Oh.
No, the one thing that I realized we didn't cover but was in your packet was the annual notices and annual hearings document. That one continues to get longer. That's one that I would absolutely, though, spend some time with. We only added a couple of things to that this year, and so I don't think they should be major changes. I was just going to tell you the attendance, or no, that's not it. Change. Sorry, just a second. I was there. Anyway, I'll find it. Karen can go on to the question. These two things we added to that 18-19 annual notices document. The asbestos management plan, that's probably something that you've worked with your insurance company on. It's been a requirement in federal law for a while, but you're actually required to have an asbestos management plan especially for any of your buildings that do or may contain asbestos. And so that's one that we put in there because you're essentially required to notify all staff members, patrons, everybody else every year. A couple of years ago, we included it in our handbooks. So your student, if you use KSB's handbooks, your student and your staff handbook contain basically saying we do, if required by law, we do have an asbestos management plan, but we added this. The last thing is a couple of the changes under ESSA now require notification to all affected, basically community stakeholders, parents, and everybody else, if your school has been designated as one that is in need of comprehensive support and improvement or targeted support and improvement from your state education association, from NDE. You are basically, if you're a beta priority school, you're required to notify all of your community members that we are. So those are the two things we added to that. Just wanted to let you know. Thankfully, nothing else I don't think was added or changed. Okay.
Is it necessary to have the board approve all the forms? Nope. That was easy. 3 of you asked the same question, which is basically our district covers multiple counties. Do we have to reach out to all the county attorneys that our school is in? The law is not clear. I think you could take the position that is for your headquarters. What do you say, Steve?
I've generally gone wherever it is you're headquartered. But I think this, again, is one where you call the county attorneys and say, hey, you know, we're a Butler County school district, but some of our land is in the surrounding counties. Do you want us to call you? And I think you just follow their guidance. But my guess is the county attorneys are going to say, no, I don't want you to call me unless the violation occurred in my county. Don't waste my time. But I would double check with the county attorneys and make sure.
I would say that what Brian thinks he drafted and what he actually drafted is not exactly the same thing. Because I think Brian thinks you would call every county attorney. So. Okay, what are the repercussions if you have a policy against student memorials? The crisis team recommends no memorial, but the board votes to override its own policy and the crisis team recommendation. That would never happen.
Let's say hypothetically that does happen because you have 200 pissed off patrons at the meeting. The fact of the matter is, if your crisis team says we recommend that you don't have one and the board overrides it, the board has that authority anyway. The board could change its policy. The board could say, we're going to scrap our policy for purposes of this decision. So it all really does rest with the board. So even if the board had a policy, we'll defer to the crisis team and shall never change their conclusion. They totally can. So that's why we think it's better to acknowledge that, the reality of it, make the board decide if it wants that authority, and at least you've got a fighting chance of enough, at least a quorum of your board members saying, no, we addressed this outside of crisis time so that we didn't bend to the whims during crisis time. That being said, what are the repercussions if the board overrides its own policy? You've thrown wide open what we call a First Amendment forum. So if the parent said, I want to have an open chair at graduation, or if the parent said, I want to hang a plaque, you've basically conceded that, yes, we're going to do that, which begs the question of what can and what must you honor the next time. So if there is a parent in the district that wants to do something which the board does not like, for example, they want to put up a park bench and they want to have a big glowing quote from the Quran on the park bench in front of the school. What is the board going to say? Because they've now asked you to make a determination between a plaque being okay because it had a Bible scripture and a park bench not being okay because it has a quote from the Quran. They've basically opened themselves up to having to call balls and strikes, which, as all of you know, under the First Amendment, is why we have jobs and is particularly dangerous. So that's why I think a standard uniform policy, Karen and I looked at each other and said, should we launch into this while we were going through it? We decided not to, but this question from Jeff is a good one. They basically said, we're going to allow you to petition us for whatever you want. And if they say no, because they know that that park bench with a part of the scripture from the Quran on it will not be popular, and they say no on that basis, now you've got a lawsuit, you're going to have a park bench or you're going to pay a bunch of money.
Let me give you, this isn't a memorial, but it's an example of forum analysis, and it's just something that happened this graduation season. I don't know if you guys saw the article about Hastings High School not allowing a girl wear a stole that I think said U.S. Army or Go Army. My daughter graduated from Hastings College last weekend, and at Hastings College, they allow kids to decorate the tops of their mortar boards. And one kid literally had written "Hail Satan" on the top of his mortar board. So if Hastings High allows the girl to wear the Go Army stole at graduation, that little D-bag that wrote "Hail Satan" on his mortar board could wear "Hail Satan" on his stole. We're not making this up. This is not, oh my gosh, Karen, Bobby, Tim, Steve, you guys all have, nobody's gonna ever do that here in Hastings, Nebraska. 100% they will. And so talking to your board about the fact that if you let one family have a memorial that says, whatever the Latin is for rest in peace, then the next family that says, we want a memorial that says it's all the superintendent's fault. Once you open the forum, you're gonna have to let them say whatever they want, which is why, one of the many, many reasons why it's such a bad idea to let people have memorials. Even putting aside the fact that it's psychologically damaging to children, which in my mind should be enough, there are tremendous practical and legal implications to opening up a forum to these kind of memorials.
Columbine High School, for example, I just got into this recently, they got sued because they put up a big shrine memorial when they had the terrible school shooting there in the late 90s. Well, then they had a family whose, I think, son or daughter died in a car accident. It was something like a tragic death. Everybody felt really bad about it. But they said, hey, you've got the victim memorial from our school shooting up. We want to add a memorial for our daughter that died in the car accident with this inscription. They said, no, you can't do it. And so Columbine High School got sued because they allowed a memorial in one case, which for the school shooting everybody supported, but they wouldn't in another case, at least in part arguably, because the message or the family wasn't one that we wanted to have a memorial up at the school. So there are actually—
I think Columbine's been sued 3 times over that memorial for various things. So,
which I don't think anybody disagreed with when they put it up the first time, but it's an example of that forum concept.
So sorry, Jeff, that's a long answer to your question. The board, the truth of the matter is, if the board says, hey, Mr. or Ms. Superintendent, we don't care what you say, we're gonna do it, they're the boss. But we just think it's a really bad idea. Okay, I'm gonna unmute you all and it'll be a madhouse if anybody wants to ask a question out loud.
Can you hear me?
Oh, hey, Barry. Yeah.
Yeah, just going back to the student discipline, I was just kind of going through our policy book and looking at what we had. Would you recommend then that if we've got both the 50-34 and the 60, whatever it was, get rid of one? Just put it in one place?
Pick that around. Yeah, I think it's easier to keep track of it if it's only in one place.
Okay, but it can still be, like, even if it's in 50, 30, whatever, it can still be included in the student handbook and
Absolutely.
places. Exactly. Okay.
Barry, your question is exactly why we put it in one place, because we
Okay.
school
We have a camera.
not the other.
Uh-huh.
That's why we started including handbooks for our full service subscribers, so that we made all those changes and it wasn't left to you or a principal to remember to change all those places.
Okay. Thank you.
Anybody else?
I guess, how would you suggest, I don't know if you can hear me or not, how would you suggest doing the handbooks? I mean, we updated all the policies this year, ignored all the handbooks. That'd be my next focus. What should I do with my board as far as that goes?
I would recommend, Adam, that you start using our form handbooks. They're included as part of the, if Adam's at Cody Kilgore, they are a full service subscriber. Included in that will be handbook updates. So if you don't want to be tasked, that's why we include it. If you don't want to be tasked with going through and putting the change that Barry was talking about into the handbook that your board has, which is different, and that would be one benefit. That's what we recommend to any service subscriber. Then
Right by the bar.
Oh, hell yeah. Well, that way the personal assistant will break far.
Right. Oh, yeah, that's right. We have a personal assistant. We don't need to be right now. That's
Yeah.
Well, the person you hear talking is Sherry, which I'm going to mock her. So, oh yeah, now she looks. But to Bobby's answer to Adam's question, Adam, remember it's a service. So if you've got like Cowboy Pride Day and everybody drives tractors to school, which some schools have, and you want to have that in your handbook, there's, we can customize it to what you need. But having the bones of ours, I think, is the easiest way to start. Hey, Jane, are you talking?
No.
Bobby, you talked about how do we update that or who develops that asbestos management plan?
Oh, I think that's you, Randy. We can't hear you very well.
Yeah. Asbestos management plan. How do we update that or who updates the asbestos management?
Yeah.
Asbestos.
Yes, I think the question was this asbestos management plan. Steve, you want to? So it isn't. We do not have a form asbestos management plan. I know that at least AliCap a few years back went around and helped do a lot of mitigation. I think as part of that, they discussed compliance with the federal law requirement for an asbestos management plan. I think the long and short answer, Randy, is it's going to depend truly on whether you have any asbestos present and what, if any, mitigation training you provide, say, to your custodians. So it's not like there's some fancy form. There are a number of these plans, right? You've got a safety and security plan, a pre-existing plan. We don't necessarily have form documents for those, but for the asbestos management side, it basically, I think, has to contemplate if you have asbestos, where it could be located, steps you've taken, obviously, to avoid any negative impact of it, and training you provide to your custodial staff in the event, you've got a pipe that bursts and they have to get into a wall. So it truly, I think, is going to be, I don't think we could never have a form asbestos management plan. And if you have those issues present, let us know. And we can certainly reference what the federal regulations say about what else must be in.
There's also companies that'll help you with that. So if you have that management plan, they'll come and visit that each year as part of that plan and then tell you where things are at and everything's changed within that. So,
Perfect.
Randy, let me know if you need any help with that.
Thanks, Josh.
Yeah, that's awesome. Okay.
Anything else for the good of the order? Okay,
Thank you.
Thanks, guys.
Sherry's going to send a link to this out. We're also going to send a quick little survey we want to know if this is helpful and if you like this format and whatnot. So if you'll take 2 seconds, I promise we read that and we really take what you say to heart. So if you do that for us, that would be awesome.
Okay.
All right.
Thank you, everybody.
Thank you.
Thank you.
Thanks.